So nearly 10 years had gone by since the USERRA law had passed. There was not a lot of action on it. And it's important to understand why. When I was young, everybody's grandfather, uncle, father had been in the service because they were drafted. The draft ended in the 70s, and we have an all-volunteer force now. We've had it for decades. It works well. But given that it's an all-volunteer force, it affects a much more narrow portion of society than it did when I was young. So you can look long and hard and not find a vet among your friends or immediate family, completely unlike it was a generation ago. Now, if we take that, and the estimates are about 1% of the country now serves in the military. If we take that and we take the numbers in the National Guard and Reserve, we're looking at about 1/2 of 1% of society. And given that we had really not a lot going on until September 11th, we can understand why these laws were not tested, were not implicated, because they didn't need to be. National Guard and Reserve component members go on what they call drills, where they're there generally a weekend a month. They generally go maybe 2 weeks a year, maybe 3, 4, depending on if they're getting any advanced training. But they really had not been called to active duty for the decade of the 90s. Well, that all changed. As I mentioned earlier, whatever state you're watching this in, you've probably had a National Guard unit activated. We had one here in Illinois. It was activated. They sent a brigade combat team to Afghanistan, and they took heavy casualties. We've seen it here in our state. You've seen it in yours. To understand USERRA, we need to understand the reason behind the law. And Congress has 3 specific purposes for USERRA. The stated purposes of USERRA are, first, to encourage service in the National Guard and Reserve by minimizing the disruption to the service members' civilian employment due to their military service. Second, to minimize disruption to the service members' employers, family, community, and coworkers by providing for prompt reemployment upon return from military service. Third, to prohibit discrimination in employment and reemployment against National Guard and Reserve members because of their military service. Who is covered by the USERRA law? Any employer, basically, whether they're civilian, state, local, federal government, profit, nonprofit. All you have to have is one employee, and if that employee is a National Guard or Reserve member, they're protected by USERRA. USERRA is intended to protect those performing military service in the armed forces of the United States. And that's whether that service is voluntary, where the citizen soldier volunteers to deploy, or involuntary, where those citizen soldiers receive the letter from Washington, D.C. that says, greetings, come spend some time with us in Afghanistan. This applies to all National Guard and Reserve components, so Army Reserve, Air Force Reserve, Coast Guard Reserve, Navy Reserve, Marine Corps Reserve, and the National Guard. And as I mentioned earlier, the National Guard performing federal service. So when it's an Army unit, or when the Air Guard is activated to be an Air Force unit. If the National Guard is activated for a state function, state mission, then there'll be separate protections under state law, but USERRA will not apply for state activations. It's also important to understand the relationship between USERRA and other laws, regulations, and so forth. USERRA doesn't supersede other laws, but what USERRA does, it requires that those laws, regulations, or collective bargaining agreements do not infringe on USERRA rights. The theory here is that other laws can grant more rights under USERRA, but those other laws, rules, regulations, and collective bargaining agreements cannot infringe upon those rights and take them away. I mentioned earlier that USERRA has 2 components: anti-discrimination against Guard and Reserve members under Section 4311, and reemployment rights of Guard and Reserve members under Section 4312. Let's start with Section 4311. the anti-discrimination provisions of USERRA. We're all familiar with anti-discrimination laws because we've heard about them growing up, and we're exposed to them in the media. Equal employment opportunity laws, anti-disability discrimination laws, the Americans with Disabilities Act, the Family Medical Leave Act, all sorts of laws. USERRA is similar to that. Some of the commentators have said it is the most comprehensive piece of civil rights legislation passed in the United States. But because it affects such a narrow portion of society, 1/2 of 1%, we never really hear about it, and we're not exposed to it in the media. The anti-discrimination provisions for USERRA prohibit a number of things. They prohibit discriminating against somebody because they're in the National Guard or Reserve in the initial employment application. So you can't deny somebody employment because they're a Guard or Reserve member and might get activated, or might deploy, or might come back disabled. You simply can't do it. If you do, it is actionable under the USERRA law. Now, when the employee is in the workforce, the anti-discrimination provisions prohibit a couple of other things as well. Like any anti-discrimination law, be it a civil rights law, whatever. You can't take an adverse employment action against an employee because they're in the National Guard or Reserve or the military. You can't retaliate against them. Say they deployed, you can't then demote them. And you can't deny them any benefit that attaches to employment because they're in the National Guard or Reserve. Just like with the initial hiring provisions, if you do it, it might be actionable.